mentioning now.
Special bench.
I appear in item 301. This is an application by the state of Maharashtra, my lord. This is with respect of the Zudpi judgment which your lordships had passed. And my lord, while most of the concerns I must say are addressed, I would seek your lordship's attention only to two clauses, my lord. My lord, may first come to page 13 of my application.
Page 30.
13, my lord. My lord, I'll first take your lordships to the conclusions in the main judgment. Let me see page 143, conclusion, Roman 7. This is the first clause, my lord. Page 143.
Page
143, my lord. 143.
yes.
We direct that the state of Maharashtra shall declare all the unallotted fragmented land parcels, each having an area of less than 3 hectares and not adjoining any forest area as protected forest under section 29 of the Indian Forest Act. Now, if your lordships turn to page 13, while we had started implementation of this, there were certain difficulties which were faced. There are most of these land parcels are not even 3 hectares, are below 0.1 hectare, my lord. I have given that classification at page 47 to the IA. It's just a table. And my lord, secondly, they are right in the middle of either villages or gauthans or other urban areas, as your lordships would see. So, my lord, they cannot, for any meaningful forestry purposes, be as such be used at my instructions from the forest department. Now, my lord, therefore, the prayer is that such lands the state be permitted to use only for the purposes which are mentioned in section 3, subsection 2 of the FR Act, the Forest Rights Act. No commercial use, nothing, my lord. Only for those purposes which are for the benefit of the gauthan or the village. My lord, the second clause is your lordships would find at page 144, because your lordships had regularized all the allotments which were made. But my lord, there were some encroachments, barring commercial encroachments. I might make that very clear at the outset.
Commercial encroachment,
yes,
we will not go.
We don't seek to protect those, my lord. We don't seek to protect those. My lord, may see page 144. This is the second clause that, my lord, we are facing some difficulty, and it may be with the spirit of the judgment, my lord. Page 144, point Roman 10. Because your lordships had specifically said that the housing must be protected. We further direct that your lordships have page 144. We further direct that a special task force comprising of the subdivisional magistrate, deputy superintendent of police, and assistant conservator of forest and a taluka inspector of land revenue of land records should be constituted in each district to remove encroachments within a period of 2 years from the date of the judgment. We clarify that these officials will be posted only for this purpose and will not be assigned any other duty. We further clarify that all allotments for commercial purpose post 25th October 1980 must be treated at par with encroachments. Now, what in the course of the arguments and what the spirit of the judgment is, encroachments, in my respectful submission, we will have to distinguish between encroachments which are used for residential, public housing, schools, Zilla Parishad offices, and commercial.
They have already protected it.
No, my lord. So, if your lordship see, clauses 1 to 4 relate to allotments in the impugned judgment. 7 relates to these fragmented land parcels. And my lord, 10 is encroachments. But encroachments has been used in an omnibus sense, my lord. If your lordship see page para 112, that is the spirit of your lordship's judgment. Para 111 and 112 at page 125. And my lord, we have given a breakup of these encroachments.
Yes, that we have seen.
at page 49. No commercial encroachments are sought to be protected. my lord.
What should be the cutoff date according to you?
Yes. So, my lord, the 12/12/1996 judgment, as far as
You are saying that any allotment after 12/12/96,
yes,
the state has to give special reasons and
yes, my lord, the same procedure can be adopted, barring commercial. The same procedure as is in clause 1 to 4 of your lordship's judgment can be implemented for these residential encroachments also. Lord, because I must admit candidly that these encroachments to a certain extent over the years were also had tacit support of the local authorities. They provided electricity connections,
local authorities, local politicians.
as it may be. I cannot say more on that.
Yes, Mr. Parmeshwar.
That's this term encroachments, because your lordships recollects when I had placed the CC report also, the CC used encroachments when there was no formal letter of allotment. Lot of schools, dispensaries, public health utilities are also classified under that.
Yeah, we have schools and
There is no formal letter of allotment. They were classified.
so we will say that this in paragraph 10, we said that this will not, this clause will not be applicable to such constructions which are used for residential purposes and public purposes like schools, so and so, made prior to 1996.
Well. So clause 10 is not applicable to those areas covered by clause 2. Would the lordship kindly see clause 2 for a minute? Clause 2 covers that. Now that is first part of the clarification they want is that.
Allotted to, the question is, there might not be allotments.
So even if no allotment in the regular sense of a formal allotment, but if it is for a public purpose as they have sought in the
Purpose or residential purpose.
whatever, public, residential, slum, hostels, schools, dispensaries, etc. Two, post 12/12/96, the same may not be treated as encroachment, but may be regularized following 3, 4, and 5 onwards.
So that is not necessary, yes.
Because otherwise those encroachments will never get regularized otherwise. So that's what I said. Prior to 12/12/96, Milods governed by 2, and they will not be considered quote unquote encroachments because they were all for public purposes. Post 12/12/96, they will be regularized using the same clauses 3, 4, 5, 6, 7.
Yes, ma'am.
Because there also the government will have to justify why they are seeking relaxation post 12/12/96. Suppose
And what about the first clause with regard to
fragmented land? Because section 3(2) of the Forest Rights Act is anyway not obstante. Would your lordships kindly see section 3(2) of the Forest Rights Act 2006?
We have copies.
Just passed up. Because it is anyway a non-obstante section 2, Milods. Would your lordships kindly see 3(2)? I don't think there can be difficulty because there's statutory exception carved out to Forest Conservation Act. 3(2), Milods, of the Forest Rights Act. Starts with a non-obstante. At the foot of page 4, lordships will see. Notwithstanding anything contained in the Forest Conservation Act, the central government shall provide for diversion of forest land for the following facilities managed by government.
So we'll clarify that
of trees. So
in view of so and so, the permission is not necessary and those lands can be used for this purpose.
subject to 2 conditions are mentioned in the statute, that the Gram Sabha, the people who reside there, they themselves initiated that.
Yes,
that proviso is there. That proviso is there. Your lordships have seen the proviso? Sorry.
Yes.
The proviso
That such diversion of forest land shall be allowed only.
less than 1 hectare and the Gram Sabha provides.
Yes.
Well, it's a couple of things. This seems to be a departure, particularly
No,
fragmentation.
the entire judgment, the only purpose of the judgment was for protecting such constructions which are already been coming to existence like school,
Right.
slums.
That is on the encroachment part, Just can we leave, if we can leave that aside for a moment. I'm on fragmentation first, That's important because your lordships, I'll show the chart of what is really left. This whole exercise was only dealing with 2 issues, 2 or 3 issues, out of which, the whole thing has been diluted. I'll satisfy your lordships on that. Please give me 5 minutes. Now, my lords, as far as this, the CEC recommendation, which was a very well thought out recommendation on fragmentation, that appears to have been completely diluted in this process. Section 3(2) refers to less than 1 hectare. So, my lord, that falls at a different, we are talking about less than 3 hectares. Now, my lords, please see the CEC recommendation for a moment, if I may read that. It follows, and it is a carefully...
So, rather than 3 hectares, we'll say that less than 1 hectare. Because 3 hectares, you can do plantation.
Yes, my lord. Less than 1 hectare.
So 3 hectares is 7.5 acres.
Because
Therefore,
they only want those projects saved under the Forest Conservation Act. Whatever is there in 3.2, if they give permission, the government should be satisfied.
in fact, my lord, all the instances that we have annexed are less than 1
Less
hectare.
than it's 0.01 hectare according to them. Listen,
So we say that instead of 3,
Less than 1 hectare.
less than 1 hectare.
Yes, my lord.
whatever is said in 3.2, the statutory compliance, they only want a statutory exemption to be made for protected forests also. So only.
My lords, sorry. Yes, my lord, what I wanted to point out is the FAC and the C, which was part of the CEC recommendations, which your lordships had accepted. Please see if your lordship, if I may just trouble your lordships with the CEC report on this, because very clearly the CEC had thought it through, and the CEC had said that yes, there may be urban clusters around, but we want these fragmented areas, and that is, we're talking about more than 29,000 hectares. It's a very large area, admittedly, so they have stated it in their IA. Now, please see, my lords, if your lordships can see the CEC report for a moment, page 45. Page 44 of the, my lords, the CEC report. Correct? Yes. My lords, they were very clear in protecting these. Please see page 44 for a moment. 44, my lords, subpara D. D for Delhi. Your lordships have minutes of the meeting of the Forest Advisory Committee held on 26/10/2017, wherein it was recommended that the recommendation of the state government that 86,000 so-and-so Zurpi land with the following present land use should be denotified for any purpose, including non-forestry, as decided by the Revenue Department and not according to legal provisions. Please see C. Fragmented land, etc. My lord, they have described as in excess of 32,000 hectares, but we are concerned with excess of 29,000. Now, my lord, so C, then please see para 4 below. Para 4 below, it says 33,229 hectares of fragmented piece of Zurpi jungle, which are being treated as small patches of the forest, should be maintained as forest land and developed and maintained as a village or urban forest by the state government. If any of these lands is required for non-forestry purposes by the state government, then the approval under section 2.2 of the FC Act will be mandatorily required on payment of NPV and compensatory afforestation and other mitigation measures.
We are saying that.
They don't want that. If
No,
that is so,
and this
We are not going by what they want. We are going by what the learned amicus is saying.
May I make a statement, my lord? We'll declare it as a protected forest. Only clarification is that section 3.2 uses may be permitted. That is all, my lord.
And there can be, those even small patches are there.
Yes.
In Maharashtra, there is a concept of Devrai,
Yes.
like Orans in Rajasthan.
Yes.
So you could have the
Yes, my lord.
forest in the small land of.
that is what we are
Yeah,
saying.
let the and whenever you want an exemption, you go under the 3.2 of the.
That was your lordship's direction, my lord. So where is the question of a modification? That
There-
is your lordship's.
Declare it as a
Please
protected
see,
forest,
please
but
see.
my statement may
No,
be
no, no.
recorded.
My lords, please see
will be
page
declared as a
43,
protected
143 of your lordship's judgment. And your lordship specifically referred to unallotted fragmented land parcels.
Correct.
My lords had held at 143.
The state of Maharashtra has filed the present application with paying for following clause 1 and 2. Correct. Insofar as the prayer in 1A is concerned, we are not inclined to entertain the same. So, however, it is clear from the provisions of subsection 2 of section 3 of the scheduled tracts and other traditional forest dwellers, recognition of forest rights into Act 2006, that provisions therein begin with the non-obstante clause. Also, if the state desires to use any of fragmented land parcels which we have directed it to be declared as a protected forest, the state can always take recourse to the provisions of subsection 2 of section 3. Also, we are therefore not inclined to accept the prayer clause 1A and reject the same. We direct that all such fragmented forest land shall be declared as protected forest. So, however, to clarify that if the state desires to use said land for any of the purposes mentioned in subsection 2, the same can be done only after following the procedure prescribed therein and subject to fulfillment of the conditions specified therein. Paragraph. Insofar as prayer clause 2 is concerned, prayer clause B is concerned, the perusal of the judgment would reveal that one of the main reasons why we were inclined to grant one-time exemption was that over the years, and on account of apathy of the public revenue officials, the necessary revenue entries could not be made over a long period of years. The land has been used for the purpose of agriculture, kacha houses, pakka houses, slums, government employees colony, government or AP schools, private schools, and other public utilities. First of the Central Empower Committee, in the report itself, has recommended protection of such structures to the extent of 10,365.049 hectares. In that view of the matter, we are inclined to follow prayer clause 2, paragraph. After clause 10, in paragraph 138 of the judgment, we direct the following paragraph to be added as para 10A. First, we however clarify this. The direction made in paragraph 10 would not be applicable for the encroachments made prior to 12/12/1996 for the purpose of agriculture, kacha houses, pakka houses, slums, government employees, colonies, government or ZP schools, private schools, and other public utilities to the extent of 10,365.049 hectares, as has been observed in the report of the CEC. Paragraph. Insofar as any encroachment which has been made prior to after 12/12/1996, and if state government desires to regularize the same shall be done only in accordance with the provisions of clause 2, 3, 4, 5, 4, 5, and 6 of paragraph 138 of our judgment dated swan.
One clarification, Your Lordship. Your Lordship says this confusion arose because CEC themselves categorized all government schools, these dispensaries as encroachment, quote unquote
So
encroachment.
that is what we have observed, as found in the report of the CEC.
It's technically not encroachment in the sense because these are all government buildings, that's why.
The High Court is also on that building. The High Court judges bungalows. The Secretariat. Yes, Mr. Where what?
He's saying now those will get regularized, as you're saying. This later part of the report, all those now get regularized.
The High Court building also.
All of them.
Anything remains now?
That's all. I'm grateful.
No, I'm sure they're taking action against the officers who are responsible as recorded.
We have now.
They have not stated anything about that progress.
It's hardly any time from the date of the judgment.
Obliged.
Yes. So, not to be deleted.
Please note 802.
Not to be deleted.
Obliged.
Already there are 29 August.
My lord, early listing of this contempt petition.
What is the urgency in contempt?
This is regarding the abrogation of the Article 370. The Lordship in the judgment 11/12/2023 directed the Union of India to take steps for the restoration of the Union Territory of Jammu and Kashmir to statehood.
Call it 10th of October. Not
The early date, my lord.
10th of October. We are already in the midst of a CB.
Grateful, my lord.
So, आगे करो.
Lordship, this is a contempt petition. Lordship has passed a
Yes,
trial.
804.
804.
So called out, you are not there. Yes, proceed.
Your Lordship, it's a early hearing application, Your Lordship. Your Lordship, on 16/5/2023, Your Lordship was pleased to issue notice and granted interim relief of stay, subject to the depositing of the amount by each petitioner within the period of 8 weeks. Till date, they haven't submitted any amount, and the matter is still pending.
2-3 हफ्ते बाद.
Lordship, this is a contempt petition. Lordship has passed a direction on 17th February 2025 to provide all the financial benefits after getting promotion within 3 months after passing that order. But my Lordship, that 3 months is completed on 17th May 2025, but yet order has to be complied by the respondent. So my Lord, kindly.
3 हफ्ते के बाद. Yes.
Please, my lords, these are the Safai Karamcharis of Jammu Kashmir who had come before your lordships for minimum wages. My lords, in February, the matter was directed to be listed within 3 weeks. I'm only requesting if the date showing was 28th, if it can be listed on 29th, because my lords, on 28th, it won't be taken up because of the reference matter, my lords.
29th to the
Deeply obliged, my lords.
Lordship requesting for not to be deleted from the call list of.
Yes, not to be deleted. Yes.
Lordship, the petitioner has preferred the petitioner has preferred the writ petition for the constitution of the SIT to prove the extrajudicial killing of her husband and 2 other jail inmates on dated
What do you want?
So, your lordship, the matter may be fixed for hearing and may be decided on merit. No tentative date is showing, your lordship.
28th not to be deleted.
So this is matters regarding environmental clearance for a medical college. This was earlier listed with Vanashakti matter, but the bench led by Justice Sok detailed that matter from that batch to be heard and listed to be heard separately. But now Vanashakti stands disposed of the detailed judgment, but my matter is not listed at lordship. Why the building permit is not renewing for want of is a medical college lordship. Maybe listed on next week lordship.
3 हफ्ते के बाद जिस दिन ग्रीन पेज रहेगा
Lordship, the main matter challenges the virus of the Gangster Act. The main matter challenges the virus of the UP Gangster Act specifically. Now, the respondent is not filing counter in the last 9 months, whereas the trial court is taking the trial on day-to-day basis.
The constitutionality of the Gangster Act. Our counter is gone for signing. It was supposed to be listed tomorrow before my lords, but I think my lords are in the Constitution bench. I think they're saying that the trial court is continuing. This is constitutionality of the Act. They are seeking a stay on the proceedings. Anyway, they have a no coercive steps order from my lords.
Okay, next. When will you file your counter?
My lords, this gone for signing today, so it will be filed by tomorrow, my lords.
Next week.
Next
Monday.
With my lord permission. The lordships are granted.
No mentioning for senior.
No, on Friday, your lordships
granted. No mentioning permitted for senior.
Lordship said I can mention.
No.
Because that matter.
No.
With my lordship. Sorry.
You pay cost how much?
No, not cost.
No. We have made it clear. How much you are donating to Spora and.
Lordship asked me that mention it on Monday because.
No. We have made it clear that no senior would be permitted to mention.
It was said to me. I was.
Or if you want, then we'll pass a resolution withdrawing the ground. So that you can start mentioning from tomorrow.
And then misunderstood, my lords, your lordship.
No. We have made it clear that no senior would be permitted to mention.
I misunderstood, because what fell from your lordship was mention it on Monday if he's not released on. That's why I came.
No. You got to ask this Sharma to mention it. We don't permit any senior counsel to.
It's fine. I misunderstood since I had appered in that matter, so I thought.
No. No mentioning for seniors.
No difficulty. Sorry,
let there be some scope for junior lawyers.
No difficulty.
So how much cost?
As your lordship desires, my lord, I cannot.
You pay something to Scora and SCBA on your own.
Not to Scora, my lord. We are not very fond of.
Okay, SCBA.
There's a big rift nowadays between Scora and SCBA.
Yes, we shall.
My lord, this order was passed on Friday, where my lord you had granted bail. But my lord, what is happening? Even the High Court, where bail was granted on 12th of August, the sureties has not been accepted. And even for the bail, my lord, you had granted on Friday, they're not accepting the sureties. It's pending verification.
My lord, so I'm applying for the respondent listed in this matter. They have not filed any application. As per the instruction I have received, my lords.
My lord, we filed the application.
If they file an application, I received
you direct authorities to. Otherwise, we will issue notice of contempt.
My lords, we have already, my lords, just kindly consider, my lords, sir, we have not received any document for the verification, my lords. If lordship say, then we will release immediately, my lords, without any verification, my lord.
To release him by today evening.
My lords, without verification, my lords. Without verification, my lords.
My lord,
they have not filed
the
any
order
application.
Passed on 12th of August also.
My
They're
lords.
verifying the sureties in that matter also.
My lords, they have not filed any document for the surety, my lords.
My lord, we've placed the application Saturday. The application is not accepted. We have again placed the application today morning. The judge is not sitting. I've been told to sit at 12 o'clock.
You tell your IO or whoever it is, if he is not released by today evening,
my lord, there is only.
We will issue a contempt notice tomorrow.
My lord, there is only one submission, my lords. I'll convey the message, my lord. There is only one message, my lords. My lord, the jailer has to release the petitioners, my lords. My lords, they have not filed any application for the verification, my lords. If we received any document for the surety verification, immediately within an hour we will just conduct the surety. Immediately, my lords, we will.
You give a copy of the documents to him.
Oh.
If he is not released by today evening, we will
My lords,
issue a contempt
my lords,
petition.
my lords, from our part, my lords, there is no fault, my lords.
Tell your IO that he has to tell the court also that he has to be released today.
Not submitted any application to the court order.
If court will pass, my lords, any order, my lords, then we will just give it given a shorty orders, my lords.
Give the copies and if by tomorrow, by today evening he is not released, you will be in big trouble.
Both the FIRs, my lord, because
He has to be out of the jail today.
With my lord permission, my lord.
He has to be out of jail by today evening.
My lords,
Otherwise, your IO will be in jail tomorrow morning.
my lords, definitely he will out of the jail, my lord. That's
Yes,
what
you tell the court also.
But
Would have to come to the court order.
Okay.
my lord, we already filed and it's order of the court.
Please ensure that he is out today.
my lords, definitely,
Ensure that he is out today, otherwise your IO will be here tomorrow morning.
definitely they will release today.
You take the documents and send them by fax.
Correct, my lords.
With my lord's permission, may I?
My lord, if there is any issue, I'll mention it tomorrow morning again.
Tomorrow the mention he will not be.
My lord, then on
If he has got the message, if he is not released by today evening,
My lords, there is
the Friday your IO will be here.
my lords, there is one submission only. My lords,
Don't make any submission now.
my lords, only one submission is requested.
If we observe on the conduct of your state government,
I'm not saying anything, my lords. There is only one submission, my lords. There is a process that the magistrate has to issue a warrant to the jail authority, my lords. If that has been issued to the jail authority, then it will be released immediately in evening hours, my lords.
ensure that he is released by today evening. We are telling you time and again.
My
If
lord,
you don't understand, then we'll make you understand on Friday.
With my lord's time, sorry.
With my
And
lord.
the Abhishek Sharma, if next time you get senior to mention, you will be saddled with cost. Yes.
With my lord permission, my lord.
May I make
This is a
my lord-
peculiar, this is a peculiar situation, my lord. I am a victim caveator, my lord. State is not curing the defect more than 6 months, my lord. My lord, the same thing is the accused is a big politician, my lord. They filed only taking the stamp, my lord. Same thing is happened in the earlier SLP also. They are not curing the defect at that time also, my lord. And that SLP was dismissed. And this SLP is also passed the order in July. They are not curing the defect, automatically dismiss the SLP. I am the victim caveator, my lord. The crime against the my lord, women, my lord.
Lord, what can we do?
My lord, list this matter, my lord. List this matter, my lord. At least impugn judgment will be
How can we stop dismissal?
impugn judgment can examine by this honorable court. The crime against women, my lord. This is a very speculative.
Lord's kind permission, may I
My lord,
mention?
this is only one thing, my
The
lord.
listing of a bail application, Lord.
Only one thing, my
The
lord.
matter listed before Justice Amanulah's bench, Your Lordship. There I mention on 5th August for on account of my son's cancer treatment, Lordship. Lordship directed to list it for 13. 13, the matter was listed in the regular category. I tried to mention before Honorable Judge. He says since it is not coming in the mentioning list, he will not hear it. And the registrar is not taking the mentioning, saying that matter is the regular category. I'm listing only for the bail application to be.
Yes, my lord.
Friday, Your Lordship.
Fresh petition, my lords, to be listed.
Let the queue.
Oblige, madam.
I'm mentioning a demolition matter. It was cleared on 30th. It was cleared on 30th. My lords, it has been listed. Your computer date showed of 12th. Again, it got deleted. It is now showing 29. Today, my lords, JCBs are there, my lords.
My lords,
Today JCBs have come.
my lord,
Let there be a queue. To give the procedure, will be listed tomorrow.
With my lord's kind permission, if I may mention this matter, my lord, it's a bench of papers between Lodha and Birla. Now, between the Lodha and Birla over the assets of Mr. MP Birla.
I didn't get you.
My lord, these are matters, bunch of pending matters before this honorable court. And in a dispute arising from an order passed by the Honorable Calcutta High Court, in a dispute between Lodhas and Birlas, my lord, regarding the will of the lady. Now, my lord, those matters were directed to be listed before the chamber judge on 2nd of September 2024. Till date, my lord, the matter has not come up before the chamber judge, and only
Should have come through the mentioning process. What is the urgent?
my lord, we already filed an application, and it's a leave granted matter, so therefore I am unable to do anything further except to mention before my lord. This was the last resort.
my lord, this is
Mentioning a fair
Can I?
my lord.
So blessed.
It's a commercial suit where a substantial delay has been condoned by the High Court and the appeal itself has been listed for hearing on this Wednesday, my lords. I'm only requesting the fresh petition may be listed on Friday or next Monday as.
My lord, this is MSCT petition, my lord. This is a two minor child, my lord.
always delete the matter, my lord. The next date is 15 September, my lord. Kindly not to be deleted this.
With that, my lords, permission, my lords, this is a fresh matter. I'm requesting for listing for Friday. I'm requesting for listing on Friday. It's a fresh matter. The urgency in this matter is, my lords, my application for amendment of the suit has been dismissed by the trial court as well as the High Court. Now, my lord, the suit is kept for judgment on the 30th, which is Saturday, and the High Court, the order still not uploaded, although the case state is showing dismissed. That's why I'm only requesting on Friday, otherwise it will become infructuous.
Friday.
Lord, if I may mention a matter that
Let
was...
there be a queue. Yes.
Lord, if I may mention a matter that was listed at item 2 on Friday, Lord said issued notice, so I did not press the matter further. Then later the case status is showing that it is dismissed. Lord, I'm just passing on the names of the matter I don't state it for. Lord, may...
So we have dismissed it. Consciously dismissed it.
Lord,
We also said that we don't want the, I distinctly related, I said that we don't want the court to be a battleground for politicians.
My lords have dismissed it, I will not press it.
The lord,
I distinctly recollect saying that don't permit the courts to be battleground for politicians. Fight your battles before the electorate.
My lords, notice issued.
If you are wrongly heard, we can't help.
Lordship, I would like to mention,
Lord, 30th is the last cut-off date for the farmer. These matters are showing in September, my lord. So I am praying for 29th, my lord.
Your Lordship, I would like to...
Permission. These are those matters pertaining to reservation for transgender persons in postgraduate medical education. The results are already out. The matter was listed on 11th of August but could not be taken up. The next date is showing on the 9th of September. But if the counseling begins before that, then the petition will be rendered infructuous. May I pray for an listing on Friday?
Your Lordship, I would like to mention a matter. Your Lordship, the petitioners herein are sitting unemployed because the state of UP failed to give us the... The petitioner are sitting unemployed because the state of UP has failed to give us the EWS reservation criteria which we are eligible for. I request your Lordship to kindly list this matter on Thursday or Friday this week.
What is the urgency?
Your Lordship, we are sitting unemployed despite being the deserving candidate.
May I with your Lordship?
Lords, I'm seeking listing of two, urgent stay applications, my lords. The issue is, my lords, High Court holds that MADA is not the competent authority, my lords.
High Court holds?
High Court has held, my lords, that MADA is not the competent authority under Chapter 8. Now, my lords, there are 2 or 3 instances of building collapse recently in August, my lords. We are not able to effectively take steps, my lords, under the Act, my lords. The matter is pending, my lords. One matter was listed before Justice Manoj Mishra, one was listed before Justice Suryakant, my lords. The matter is kept on 16th of September now, my lords. My lords, requesting that the stay application be listed, my lords, tomorrow or day after. My lords, day after tomorrow, my lords, if possible.
Friday.
With my lord's permission, my lords, it's a fresh matter, my lords. Defects have been cured, SLP has been numbered, my lords. SLP has been numbered, my lords. I'm just requesting for Friday. Urgency is this, my lords. I'm a doctor, my lords. I have been wrongfully terminated, my lords, from the post, my lord, without our opportunity of hearing, my lords, without a show cause notice, my lords. 3 years I've been in the post, my lords. Now they've re-advertised the post, my lords.
When were you terminated?
My lords, I was terminated in 2022, my lords, but I filed a writ. Writ, my lords, writ, my lords, they don't hear my application for stay. And they just simply issue notice, my lords. And it's on Saturday, my lords. The hearing is on Saturday, my lords. So I'm just...
May I have your Lordship's
My lords, may I please mention, my lords?
Two Samaj Parivartana matters, my lords.
1 minute, let me.
My lords, may I please mention, my lords? This is our implement application in our Sahara matter, my lords. There are 150 employees who have not been given wages, my lords. And this application is pending since from April 25, my lords. This has not been listed, my lords. These...
May I with your Lordship's...
Yes.
May I with your Lordship's indulgence mention a leave granted matter for urgent listing, my lords. My lords, in this notice was issued way back on 21st August 2018. Leave was granted on 24th September 24. In view of the urgency, my lords, by an order dated 13 November 24, your Lordships had directed that the matter be listed on 12 December 24 in the first 5 items. My lords, after that there has been no listing. I'm only requesting for some date, my lords.
What is the urgency?
My lords, the issue here is, my lords, there was an incentive scheme. I am the respondent in this matter, my lords. And 3 subsidies, they had attained finality, my lords, the issue with respect to 3 subsidies. So, my lords, they had to pay me 129 crores, but because one issue is pending before this honorable court in this matter.
Lords, I appear for the
Obliged.
state in this matter. Lords, I appear for the state in this matter that my friend mentioned. And
Wait,
it be in the
madam.
first week of November instead of October, my lords. I'm just requesting because I'm being led by a senior in that matter. My friend informed me, so I asked.
The senior is not available in October.
In the first week of October, she's not available, and then after that, last week is anyway, my lords, the Diwali breaks.
So you want first week of November?
First week of November, my lords. I'll be very happy.
Your Lordship, mentioning a matter, election matter for Chandrapur District Central Cooperative Bank election, it's being shown on 8th of September, and all that I'm requesting is not to be done.
Your Lordship, may I mention a matter? It's a 3-judge bench matter. Your Lordship, in January, it was already, an order was passed to place it before the Honorable Chief Justice for getting the matter listed. Thereafter, it was mentioned before Honorable Chief Justice, who directed it to be listed in September, in the month of August. But we don't still have a listing date, Your Lordship. The urgency is that it concerns land which were taken by the state under the Sealing Act and now are sought to be returned by the state. So that's the urgency in the matter.
October.
With permission, with the kind permission, I'm seeking an listing for tomorrow. The urgency is that the matter before High Court is on 28th. In a bail matter, the Honorable High Court is asking for documents which are beyond the charge sheet, as well as he's questioning the investigating officer as to why certain witnesses have not been made. The matter is now listed on 28th before the High Court for final disposal. That's the reason I'm seeking the listing for the SLP tomorrow.
Not tomorrow.
Milods with permission.
28th,
Friday.
May I mention 2 Samaj Parivartana matters, my lords, 2 IS in the Samaj Parivartana matters. My lords, 2 IS in the Samaj Parivartana matters, my lords. This is the mining in Karnataka, my lords. My lords, one is a pending IA, my lords, for implementation of direction by this Honorable Court.
Unless there is a 3-judge bench matter, it can't be heard. Yes.
Milods with permission,
That's the listing, my lords.
This is a fresh application in Parsona Charitable Trust, Milods, AICT matter, Milods. AICT, fresh application in Parsona Charitable AICT extension matter, Milord.
Okay.
May I request for Friday, Milods?
Lordship's permission, I beg to mention a fresh IA on behalf of the interveners in a salt mining matter in Odisha, my lords. In a salt mining matter in Odisha, my lords. My lord, there was no effective hearing since April 2024. I am the successful tender allottee, my lords, and I have been waiting since 10 years, my lord, because there was a stay granted by the High Court. Now that stay has been vacated, my lords. Lordships may give any returnable date as per Lordship's convenience. I'll be highly grateful, my lords.
My lord, I'm praying for a listing of an anticipatory bail matter, a fresh anticipatory bail matter. The petitioner is the Deputy Director of Education, my lord, and he's been protected by the High Court since the application has been filed, my lord.
Is protected till when?
My lord, till the disposal of the order of the High Court, my lord, that is why I'm praying that the matter may be listed so that I can pray for interim relief, my lord.
Lords, may I mention one SLP number 12251. The matter was listed on Friday, Lords, in Court 7. The bench has recused from hearing the matter, Lords. I'm requesting a different bench may be assigned, and I'm requesting for an urgent hearing, Lords.
My Lord's Advocate AOR, Sandeep Deshmukh sir is online on VC wanting to mention, but he's on mute. Kindly he be unmuted.
First, my apologies for seeking this indulgence. Yes. May I seek your lordship's permission to mention a curative petition for urgent hearing. This pertains to issue of allotment of land for industrial purpose. The auction and allotment in my favor was never under challenge, but what was under challenge is only deported, because since 1993 till today, and now Lord, whilst the SLP reached to your lordships from an interim order pertaining to deposit of interest or how much the rate of interest is to be applied, the entire allotment has been cancelled. So Lord, we have filed a review petition, but it could not get through, Lord. Now it's a curative petition. Now today the urgency is this, another advertisement is issued for the auction.
So they will circulate the curative.
We have also filed an application for a request for oral hearing, if that can be granted, my lords, so that these things can be brought to your lordship's notice.
We'll see whether oral hearing should be given or not.
Very well. Highly obliged, lordships. Highly obliged.
My lords, in 10-year, 15-year-old car ban case in Delhi NCR, 10-year, 15-year-old car ban case in Delhi NCR, my lords, you were pleased to issue notice on 12th of August.
similar IAs were also listed on that day, but a notice has been not issued in those IAs. So I request you to please.
They'll be governed by whatever orders will be passing that IA. Why do you want to notice in all the IAs?
In this case, please, my lords. High Court has not yet disposed of the bail application, my lords.
My lords,
In one case, my lords have been pleased to grant bail. But my lord, what I humbly submit before your lordships, my lord, that your lordship may direct the High Court to dispose of the bail application instead of keeping it pending, and that people are rushing to this honorable court seeking bail, my lords.
My lords,
So if your
for
lordship
the
so directs,
co-accused, my lords, the matter was adjourned 27 times. My lords were pleased to grant bail at page 211. In my case, my lords, 43 times the matter has been listed.
The bail matter?
Yes, my lords. I have placed it at page 214.
High Court.
My lords,
And not only in this
therefore,
case,
my
my
lords,
lord,
I'm
in all
equally
cases
placed as the co-accused who my lords granted indulgence. And my lords, I've been in prison now, my lords, for more than 3.5 years.
But there are 18 criminal antecedents.
In this case, 2.5 years, 3.5 years otherwise. And in all.
The public official.
Yes, but whether he has been granted bail in other matters?
Yes, 211, my lords.
3.5 years.
No, that's correct. What I submit, my lords, that my lord, instead of your lordships granting bail, your lordship may direct the High Court to dispose of within a week, my lord.
Let us not talk about Allahabad High Court.
No, my lords, I'm only, my lord, saying one thing, that my lord, if in one or two cases, it's my lords exercise the power and grant bail, then it will be flooding this honorable court.
We have granted them liberty to approach this court in case the trial does not conclude.
I'm not on that, my lord. I'm only that
My
my
lord,
High
please
Court,
page
the matter is
211, it will
the
become
bail
clear,
matter
my
is
lord.
still pending in the High Court, my lord.
Accused,
I only
211.
say that if my lord, your lordship will grant indulgence, my lord, and grant bail, then the people will not wait in the High Court and they will rush to this honorable court. So, my lord may direct the High Court
So, my
to
lords,
dispose of in a week.
211, my lords,
Let it be
co-accused
disposed of
case,
in a
my
week,
lords,
my
was granted bail while the matter was pending.
Bail by my lords,
Keep it
High
in
Court
view
may
this
do so.
issue.
So, my lord may direct the High Court to consider and dispose it of within a week, my lords. So that the people may not, from everywhere across the country, will rush to this honorable court for bail in case there is some delay, my lord, in disposal of the bail
My lords,
application by
I know
the High
that
Court.
CBI has been taking adjournments over there, my lords.
Very good.
It happened 21st of August.
This is the co-accused, my lords, that's granted.
Grant of bail. The application has been vehemently opposed by the learned ALG on the ground that the petition is pending before the High Court. And it is somewhere in that if the present application is entertained during the pendency of the application before the High Court, it should set a wrong precedent. Very good. The learned senior counsel to the petitioner on the contrary relies on the order passed by this court dated 22nd of May 2025. In the case of the co-accused, correct. So the order passed in SLP number 5480 of 2025. We observed that normally we would not entertain the matter if the application is pending before the High Court. However, in the third matter, we had granted leave taking into consideration that the matter before the High Court was adjourned on 27 occasions. But in the present case, the matter has been adjourned on 47 occasions.
43, my lords.
3 occasions. But we do not appreciate the tendency in the High Court to adjourn the matter pertaining to liberty of a citizen on such a large number of dates. Time and again, we have observed that matters related to personal liberty should be entertained with utmost speed. I have taken into consideration that the petitioner has been incarcerated for a period of more than 3.5 years.
My lords, yes. But in the FIR, in this FIR, 2.5 years, my lords, otherwise 3.5 years.
He is remanded in one of the after cases, brother.
For 3.5 years, including the period undergone in connected matter, we are inclined to allow the application.
Should be released. It may one caveat to the High Courts, my lord. They should dispose of, my lord. If your lordship, one line.
Needless to say that, in view of the orders passed by us, the application before the High Court is disposed of as having rendered in progress.
No, my lords, I was saying that your lordship may make certain observation
We have rendered it, we have said that it is supposed
The High Courts, my lord, that they should dispose of expeditiously.
We have been, but how?
My lords have time and again said within 1 month, within 2 months maximum. In fact, until my lord said within 2 months, these bail applications should be disposed of.
He should be released. Yes, next matter.
Well, it's, if I can pray for being released forthwith if he is not required in any other.
That is the order we have passed normally.
So grateful, so grateful. They have to furnish the bail bonds, my lord, then whether he is required in any other case or.
Next matter is called out.
May it please, my lord, in this, may it please your lordship. My lord, void annexure P1 at page 10 of this miscellaneous application on 19th of December 2024, your lordship had granted permission to renew the request for bail in case trial is not concluded within a period of 6 months. My lord, now the latest status before the trial court is annexure P4, order dated 18th July 2025. After examining 85 witnesses, the prosecution agency has presented a supplementary challan now, and de novo trial has started.
Yes.
Your allotment, page 16.
I'm appearing on advance notice. Give me week's time. I'll place the entire order sheet. It was on the direction of the Honorable.
Okay, so notice. Returnable.
A short date.
2 weeks.
May I please your lordship? Lord, while we have invoked the arbitration and they have without prejudice done, they are questioning the consortium agreement in which the arbitration agreement lies. Now, my lord, in the light of several judgments of my lords, this issue can also, in my respectful submission, be decided by the tribunal, and it cannot have an impediment in coming in the way. Please first have played 34.
Really, a preliminary submission which can solve it.
My lord, can I just finish?
Preliminary submission, if you don't mind. There is no original of this document. Let him file an original before the court with an affidavit. Without proceedings under section 9 and going on in the Delhi High Court, where we have said there is no original, the judge has recorded statements of both parties and he seized of the matter. They don't tell your lordship this. So just ask him to file the original plan. I have nothing else to say.
Yeah, my lord, page 34 if my lords
If
don't
there is
mind.
an original plan, it can go.
Page 34.
Yes.
Yes, my lord, clause 11 at page 34 is the arbitration clause, which says all disputes and differences, my lord, shall be referred to arbitration and it shall be 3 members. Now, please have page 36, 11th October 24. Lord, we invoke arbitration and your lordship will see that we appoint, my lord, at page 43, one Mr. Vivek Kapoor, barrister at 39 Essex Chambers. You know, they respond at page 57, 10th November 24, and raise the point which I already indicated, my lord, at that it's a forged agreement. But please see para 3, last 3 lines.
No, they raise objection what?
My lord, they say that this consortium agreement is a forged.
It doesn't exist.
Forged agreement. Lord, I didn't interrupt my learned friend. But at para 3 at page 58, my lord, kindly see the last 3 lines. After saying it's a forged agreement, be that as it may, if any honorable court directs arbitration proceedings, then we nominate Dr. Bharat Bhushan Prasoon, former judge of the court, as their nominee arbitrator. So I'm only suggesting to my lords, in course of action which my lords have followed in several judgments from Maya Swami to the recent...
So where are you reading?
My lord, page 58, 58. This is the reply to the invocation notice dated 10th November 24.
If any honorable court is to direct...
Let him read the entire para 3.
Yes, yes, I'll read the entire
Please read
para
the
3.
entire para.
I started by saying, my lord, they say it's a forged agreement. Kindly see. The present reply is being issued.
So let the issue be decided by the Delhi High Court first. We will consider that.
No, that is only section 9.
Well, whatever it be, yes. If suppose Delhi High Court comes to a conclusion that the document is a forged document.
My lord, in section 9, they can't. Just let me make my point. This is an international commercial arbitration. We can only approach this court. Section 9 has been invoked by me. In the section 9, they've taken that plea. Your lordship assurance, section 9,
So let that section 9 be
Milord,
decided.
there will be no mini trial on this. That has to go to the tribunal. They're having the best of both worlds. There they say don't pass any order because there's no arbitration. When I move arbitration here, they say go to section 9. Section 9 court can't go for appointment of arbitrator. That can only be here. I'm saying, Milord, I'm saying something with greatest of respect and humility, which my lords have followed in a catena of cases. This issue, whether the agreement is forged or not, may be left open for the tribunal to consider even as a preliminary issue. But they cannot, Milord, create a logjam that there is no section 9 moving, no arbitration moving. So having the best of both worlds, defeating it. And consistently, Milord, your lordships have taken that view that if it's a simpliciter case of forgery, as he's saying, then...
Point out.
Yes, Milord. Kindly have, Milord, this judgment. Milord Rashid Raza.
Document exists.
There are several judgments. I'll just place one for my lord's kind consideration. Please have page 62, my lord. 62. My lord, this is the judgment of 3 honorable judges. I'll take my lord straight away, my lord, to the relevant part. Please have, my lord, para 4 at page 64. After noticing, my lord, case of fraud, etc. Para 4 at page 64. The principle laid down in this appeal make a distinction between serious allegations of forgery and fabrication in support of the plea of fraud as opposed to simple allegations. 2 working tests are laid down in para 25. Does this permeate the entire contract and above all the agreement of arbitration rendering it void, or whether the allegations of fraud touch upon the internal affairs of the party having no implication in the public domain? Judged by these 2 tests, it is clear the case falls on the side of simple allegation, as there is no allegation of fraud which would vitiate the partnership deed as a whole, or in particular...
There are documents, there are contention in that consortium agreement itself is a fraudulent document.
But greatest of...
It's not as if that there's some allegation which is done to interpolation of a document or something.
Just have para 6 for a minute and next page, 65. This being the case, we are of the view that the disputes raised between the parties are arbitrable and hence a section 11 application would be maintainable. I'm only recommending, my lord, this is an afterthought which they have taken up. It was signed by those people. This has to be examined. Your lordships in a 11 or a 9 do not have a full-fledged inquiry. It is only a preliminary prima facie view. I am saying, my lord, with full sense of responsibility, somebody has to unravel this. I may be right, I may be wrong.
In this matter,
yes.
At page 62, we don't know what are the allegations. The court doesn't refer to what are the allegations of.
Yes, please have page 63, the first para. The present case arises out of a partnership dispute in which a FIR was lodged by one of the parties alleging siphoning of funds and other business improprieties were committed. The FIR is at present under investigation. Now, please see, my lord, the arbitration petition was filed seeking appointment of an arbitrator, which is to be found in the partnership deed between the parties. Then the allegation of fraud was made. This is exactly why Ayaswamy was cited. And then they say, my lord, that on a preliminary view, it can go to the tribunal to examine this. Your lordships have consistently said that neither 9 or 11 will unravel, my lord, the extent whether it's fraudulent, forgery, etc. Somebody has to have a full-fledged inquiry. No mini trial can be.
The contention in the document itself does not exist.
Subscribe this. No, my lord, with that.
I'll show you
what
exists.
There is an
executed agreement
that is simply a
that he doesn't file because there is no arbitration clause.
Can I complete? I am only saying with greatest of respect. That is a plea that they have taken in a reply and filed some FIR, etc. But somebody has to go into it, is what I'm saying. Section 9 court can't go into it.
Then file a suit.
No, but there is a...
I filed a suit also 1 year ago that he is relying upon a forged copy. There is no original.
Milord, I beg to appear for spot number 3 minutes. I have denied the agreement entirely, no appointment made.
Milord, can I just make a request?
Sure, dismiss this.
Then can I make one request? Milord, keep this issue open because today the...
We are not entitled to the present petition. However, we are not touched upon the merits of the matter. And all issues available to the parties are kept open.
But a similar issue arises in this matter, my lord, in SCP 2165 of 2024, my lord, it's part of your lordship's office report, my lord. And notice was issued para 4 of your lordship's.
Page?
Your office report, para 4. I don't have the page number of the office report, but I have office report. Scott must. Para 4. Para 4. Office report. No. Sorry, I don't have the page number.
You are on page number?
Well, it's given separately, I believe.
Yeah, but that's only the multiplier issue. The other issues are not there in that.
No, we have issued notice in the matters of the landowner, but not of the.
Therefore, the issue, my lord, there are a couple of issues.
It's a question of multiplier of 2.
My lord, there are a couple of issues in this matter. The first issue is whether the multiplier should be 2. Lord, as far as the state of Chhattisgarh was concerned, my lord, we had a notification of 4th December 2014, which had a multiplicand of 1, my lord. The High Court quashed it. The High Court said it should have a range between 1 and 2. And, my lord, by the time, and that was in 2018, the award came to be passed in 2017. Therefore, according to us, my lord, that would apply. And the subsequent event, my lord, that we passed an act, which was in 2019, where we raised the factor to 2. So therefore, my lord, that is one point. The other point is, my lord, the interest, should it run from 2013 or should it run from 2015 or 2013? Lord?
13.
Now, my lord, what we have said is, my lord, the preliminary notification under 11 was only 2015. My lord, on some misreading of the testimony, my lord, they say, well, the barrage was sought to be built in 2011. Please see, my lord, the second paper book. They are still cultivating the land. What the High Court should additional documents, my lord?
Sorry, that document. Well, Lords, I take a very serious objection to the new document being filed for the first.
My lord, the Halka Patwari's report was not called for. My lord, the best thing is don't believe.
Is it not covered by both the notifications?
Sorry?
Is it not covered by the preliminary notification as well as the final notification?
Yes, my lord, we said.
If you are not taken possession, then you should not have notified it, or you should have withdrawn from the acquisition.
My lord, therefore, my lord, the interest that has been given is given beyond 2015, my lord. The preliminary notification is.
No, the interest is given from which year? From which year?
2013, my lord.
Not from 2013, but 2013 is the preliminary notification is of 2015, my lord. Would my lord just.
Grateful, my lord.
My lord, I was only as far as that.
We have issued notices in the matters of the landowners, not of the state.
State notification, my lord. That notification didn't kick in, which is multiple.
Sorry, you are before a wrong court.
But you're not sure we can do that then.
They conduct it.
Deep blue guy.
May it please. An application for appointment of an arbitrator under 11(6) minutes of the Act.
Yes. It's notice. Returnable 4 weeks. They are appearing.
Returnable minutes someday.
I'll see time to final.
Yes. Returnable 4 weeks. They are very returnable 4 weeks.
Delay control.
Some refiling delay.
My lords, this is a case where the rules of the game were changed post the game had already begun.
Why 32?
Yes, my lords.
Why 32?
My lords, in the High Court, a similar writ was already dismissed. Therefore,
that can't be a ground.
My lords, on the exact same grounds, it was dismissed. Therefore, I have come before my lords.
Sorry.
My lords may give me liberty to file 226.
You are not inclined to entertain the present petition. However, the petitioner, the petitioner disposal, it's liberty to the petitioner to approach the jurisdictional High Court.
Grateful, my lords.
Please, Your Lordship. Your Lordship, in this case, I am the applicant
How
responding.
can you write such an application in a disposal of a...
Your Lordship, I just submit. Your Lordship, just 2 minutes, Your Lordship. Your Lordship, in this case, what happened? The petitioner approached this honorable court and later on withdrew the appeal. Your Lordship, I have stand.
Civil appeal was filed by...
That's true, by the appellant, Your Lordship. but he withdrew this case.
But how can you?
No, but Your Lordship may
But
just,
get a release in that matter.
no, Your Lordship may just see now consequences is this, I could not get anything because proceedings before the National Commission.
How can you dispose of petition grant?
Your Lordship may direct at least compensation, whatever is the order
Sorry, madam.
given by the National Commission.
The relief sought in the by way of an MA cannot be granted in a dispose of appeal. Reject.
Your Lordship may direct the National Commission to consider my application.
You make an appeal. How can we direct? Make that.
Relied upon judgment, Your Lordship, being assailed by the department with regard to maintainability of appeal. That is pending here, page 64, Your Lordship.
Leave that.
Indeed, Your Lordship.
Check with the matter.
Page 64 is the detail, Your Lordship. Published.
Please, my lords. Now, so I'm seeking a pass over, my lords.
Oh.
Please, my lords.
Lord, item 10, one relief will await your lordship judgment, my lord. Regarding the NRI quota, lordship, I've advised them they have to amend the writ. There are some more documents need to be produced. Lordship may have it up 2 weeks.
But you are now.
The state quota, lordship is right. That is to await your lordship judgment, I think.
The NRI also, you don't clear 11th and 12th from. You clear 11th and 12th from Hyderabad.
Yes, my lord.
But you don't reside for 4 years.
Yes, so that is a state quota issue, which hopefully lordship will be convinced, and you know that I'm not on that, my lord.
Yeah, we don't want to discuss. Come to know.
Is here, so I can't.
You will come to know on next Monday.
Yes, my lord. So lordship may have it after that. Then NRI quota will advise. NRI quota, there's some more.
You would have come to know on today itself. Then Justice Chandra is out of India, so.
Till the judgment comes, we are optimistic, sir. So, lordship may have it up 2 weeks, my lord.
After 2 weeks.
Obliged.
Well, this elections of the village committee, which is required under the 6th schedule.
But then why don't you file a contempt before the High Court?
We have done both, and it's still nothing has happened. 5 years, they keep coming and telling the court again and again. This is a constitutional position, my lord. To implement on the ground, it's equivalent to a municipal corporation.
Issuing notice. Does the permit over it?
Requesting a password in 12. Requesting a password.
The 13.
Pass over हो गया 1 में. Pass over in 1 हो गया.
Plus, can I just show those clauses 5.1 and 5.7? Would your lordship kindly see page 89 for a minute? Because there's something that's startling.
No, this has been set aside by the High Court.
Well, that's 5.7 reservation is set aside by the High Court. Plus, I'll show him, Lord.
And Telangana, in fact, we are recommending that it should be provided this.
I understand. Would your lordship kindly see?
We are issuing notices.
Well, there'll have to be a stay, Lord, because they came after the results are declared. They went to the High Court, Lord. No, that's it. Stay.
And the only reason given by the High Court is that it has been done by executive instruction.
Because 4 army jawans, so all transfers.
Yeah, but then
they're completely out.
Yeah, but then Indra Sawhney itself says that the reservation can be provided even by executive instruction. It is not necessary to have a legislature.
Grateful.
In fact, the state of Goa should also have approached.
You're right.
Correction of a date.
Yes. Should be 31st August.
The necessary correction. Date of conviction.
I'm so.
For such matters also, why should the seniors come? At least for such matters, you should give an opportunity to the juniors.
If it may please my lords. My lords, on the first round, I approached my lords had passed an order because I was aggrieved with this interim protection granted for not joining investigation. Then moved a quashing against the FIR. on 9/8/2024, a blanket order was passed by the High Court. Thereafter, I approached my lords. My lords granted me the liberty to move the early listing application. On that, the interim order is passed. My lords, may kindly see paragraph 5. What is the stand of the state? My lords, may clearly see the state has said. My lords, returnable. And thus,
I am appearing for respondent number 1 caveator, accepting notice.
Yes, what is if you give them a tender subcontract on the basis that you have granted a main contract and contract is not awarded to you?
My lord, commercial dispute and my lord under section. They just, my lord, investigation, they want to admit the offences. That's it, my lord. Nothing there. Otherwise, we are cooperating, my lord.
The two people who are in their 70s, my lord. So I've appeared twice before the Calcutta police station. All they are saying is, please admit to the fact that you have not made the payments. Even after your lordships gave them liberty, my lords, they moved an application for vacation of their interim.
It is 13.32 crores. And 19.19 crores has it been paid by check? By check or by cash?
My lords, it was paid by check. The RTGS amount. I was a subcontractor. My lords, I'm on right now on the procedural aspects. Paragraph 5 of the court records, my lords, of the interim order. The state has said custodial interrogation is required. They have not been appeared. They have accepted notice. Let them place in.
Let the state come.
Let the state come before the court.
Their application pursuant to your
law. No, but you don't file an application for anticipatory bail and go directly under 480.
Absolutely no bail has been filed.
Would your lordship kindly see page 103? Even when they page 103 for a minute, lords. This is why a criminal prosecution has been initiated. 103 para 16. Even when they want to vary the interim order, see what the pleadings are. Para 16. Not that an offence is made out. Para 16. 103 para 16. Your applicant states that the applicant has repeatedly contacted the petitioner for payment of outstanding dues. However, petitioner evaded these queries and demonstrated no intention of resolving the matter. Because arbitration clause is there, not invoked. Civil suit, not done. 2015, they sent me a letter saying that outstanding dues are there. 2015 is the letter.
Have you filed a suit?
My lords, we haven't. My lords, my instruction.
Then you are just using the criminal machinery for recovery of amount.
My lords, let them approach. My lords, also, my lords, let them approach and make that statement. My lords, also, my lords, let them approach before the police and ensure through VC liberty has been granted. Come up and make those statements. Also, my lords may kindly see they are my lords habitual offenders.
Thank you.
My lords, they are habitual offenders. My lords, procedurally, no caveat has been filed. My lords, no caveat has been filed. I was not served a copy. Notice has been granted by my lords. Let them come up before it.
Sorry.
My lords, I wouldn't have insisted. I wouldn't have insisted on the fact. My lords, why don't they come virtually and let the police know about it? Very well, my lords.
Please, my lords. That's item 16. Your lordships have posted all these matters. It has to come before last week, my lords. Lordships have passed a similar order. This is about clubbing of FIRs. My lords, yes, may kindly see the order. Same order. My lords, actually, your lordships have reserved this case, my lords. It has to come last week due to constitution bench. It couldn't come this Friday, my lords, because lordship.
Just notice track confusion.
Please, my lords, in item 17, we have filed one amendment application with amended petition. It's an arbitration petition.
Who's anybody applying for the respondent?
My lords,
You want to amend the petition?
my lords, we have amended the petition. We have filed the amended petition. Kindly issue notice on the amended petition as well as on the application.
Notice one. 4 weeks.
Both the applications. Obliged.
18.
As per your last order, my lord, I brought that corrigendum which was issued by the High Court in additional documents. Page 6.
Yes.
My lord will find This has been there in
Page 6.
page 6.
Page 6 of the application.
Page 6 of the application. Referring to the High Court notification of 28/116.
Page 6 is the last date of the.
15/7/2000.
Page 8, yes.
Yes.
And then Anisha P8. Yes, proceed.
Yes, my lord. Your lordship will find this notification, corrigendum, they are referring to the notification of High Court 28/116, which has been part of the main SLP. Your lordship will kindly come to that notification of 28/116.
What is your qualification?
My lord, I was hired in 10+2. I was a graduate. But the question is that, as far as these honorable court's direction in Renu's matter, the High Courts were supposed to frame up a statutory rule, which has not been done in Assam. Still it's pending. Now the learned single judge has said, dismissing my review, saying that it has been done by exercising the power under Article 235 and 236, which is my lord, in that case, my interim payer is dead. My interim.
How can by interim what do you get?
My lord, because I have already been shunted out at this point. My lord.
Sorry.
Obliged, your lord.
Regarding the vulnerable witness deposition.
Yes, learned attorney, you take it.
I had a joint meeting of at least 4 ministries together and all the DDG, NIC to sit with me. They're working on this, how to develop, because a lot of high courts systems have to be.
After 4 weeks so that the learned attorney.
What I will do is after
I
maybe
just wanted to convey that the whole system has already been designed. It's only the financial aspect that we are.
No, that will also be addressed.
But the learned attorney
Lordship can keep it after 4 weeks, but what I'm saying is that it's already, everything is in readiness. It's just its maintenance because it has to be carried on even after the commission goes, your lordships. This is a module which has to carry on in perpetuity. So that financing is required.
In fact,
take the learned attorney, you want to
Yes,
copy
Your
and
Lordship.
we'll do all that.
Suggesting a joint meeting, Justice Mittal can meet
In
that.
fact, the government itself wants to take it as one of the most priority items of.
It should be taken because
it should.
You have to restore back the.
Yes.
People are very.
Absolutely.
Learned attorney, that the matter has been looked into, and various meetings have also been held. We get that 4 weeks time be granted so that some concrete proposal will be placed before the court.
Lordship, learned attorney was suggesting a joint meeting with Justice Mittal. Lordships may put it as a part of the order.
We are saying that we will leave it to him.
Yes, Your Lordship.
Not necessarily.
No, I am going to organize it.
He will organize it.
Very good. Very good.
I'm going to organize it.
Grateful.
But item 20, which is not in the sequence, but I'll talk to the other side. Lord, this was only for appointment of the presiding arbitrator. We have appointed, I'm seeking time, my lord. We have appointed
20.
Your lordship need 20. Your lordship need not open the file. It's arising from section 11. We have appointed our respective arbitrators. They have, my lord, sat together and requested us that you seek some time. We will finalize the presiding arbitrator.
Sent a mail last night saying they have appointed somebody. They're only checking his conflict. So if my lords could.
That's exactly what I was.
That's what the. So when do you want?
Lord, after 3 weeks, 2 weeks, 3 weeks.
3 weeks.
Obliged.
Obliged.
This is an application for recall matters. Recall of the order dated 4th of August matters. The petitioner matter is suffering from lung fibrosis matter. He is very critical. He is in the ICU matter on ventilator.
How can the order be recalled? If you want, you may file an application on the medical ground. But you are.
If your lordship kindly see the order matters, because if your lordship kindly come to page 31 matters.
But on that day, you made a statement that in hospital.
There
is no hospital.
No, my lord.
There is no hospital.
That is my lord, are absolutely right.
Neither doctor nor hospital.
My lord, absolutely right. Well, very unfortunate, but that is the ground matter for this recall, matter, because the person was staying at home with all these facilities. Matter. If your lordship may kindly see page.
What he is saying correct?
My lords, he has been having a vacillating stand. Otherwise, his appeal is pending before High Court. Let him move these applications there, my lords. On suspension of sentence, first SLP was dismissed on review. It was
how can there be a recall on that in a criminal matter?
And please see the order seeking recall that is recorded vacillating stand.
If your lordship present application, however, if the petitioner so desires, may file an application before the High Court.
Where his appeal is pending.
For grant of bail on medical grounds.
Please, ma'am.
That my lord, then grant me some relief for 3 weeks so that I may file. I am on ventilator, matters. I can't surrender. That's the if your lordship may grant me that indulgence, my lords, 3 weeks time to file my application, my lords.
In the meantime, we direct that for a period of 2 weeks, no courses shall be taken against the petition.
I'm so grateful. Grateful.
Indulgence of your lordships, otherwise, my lords, he was absconding for 10 years after first bail, then, but my lords, my lords may say no further applications will be entertained.
We are, our seniors, otherwise we dismiss such MAs with costs.
Yes, my lords.
Had he not been so critical, man, I would have not approached. Grateful, man.
I filed an application. There is an error in the tender. Your lordships were pleased to deal with this case.
41.
Of additional security and all, my lord, your lordship remember what was poured out. So, my lord, there is an inadvertent error which has happened, which I'll explain. So, my lord, orally, if your lordship remember, my lord, 15%.
If it is less than 15%,
then you had to give.
You have to have the additional performance security, APS.
Which was the difference between my bid and 15%, namely, my lord, I had bid 18.5. So, my lord, lower than 15. So difference of 15 and 18.5 was 330 crores. It was scored out. The High Court said, no, scoring out, my lord, is not appropriate. You have to give. Your lordships were of the view that additional security has to be given. And the benchmark will be mine. That is, my lord, anybody who wants to bid.
Anybody wants to bid, he has to go below it.
Can go below. Now what has happened is.
Not can. Only if he goes below, then.
So then opportunity to Mr. Singhvi's land to go below me. And then he will also give, my lord, the APS. As I had volunteered and he had volunteered in the court, then everybody will give. Now, my lord, an error has crept in, my lord, in the tender. Just see that. Just turn to that.
29.
Just turn to 30.
13.
30. Relevant part.
Caliber is you are for someone else.
Caliber.
So you are for the person who got.
Yes, who was L1, who has been knocked out on the ground, that additional security was not to be given. Now come to page 30. So an error has crept in, and I will explain after I read para 3. My lord, just turn to paragraph 3 at page 30 and keep that difference in view. The floor price or the base price as per SC direction will be 8,277 crores. No problem, that was my bid. And the said floor will also be treated as a reserve for calculation of APS. That is not correct. So, Lord, what it should have been is the APS.
Floor price, base price in view of so and so, will be so and so with GST. And for calculation of APS, it should be the amount below 15%. Difference between it.
Correct. So, I have corrected, Lord. In my own humble way, I have corrected how the clause should have been. Please read. Now, please read. So, otherwise, what happens is this. So, Lord, if I have 8,277 crores, if the other side bids 278, he will give APS only of 1 crore. The APS has to be of 300 crores. Now, look at this, Lord. The floor base price of the Supreme Court direction is 8,277, and the floor price and that the additional performance security shall be the difference between 85% of the justified cost finalized by the organization.
That's in 4.6. That's in 4.6.
That is not pursuant to clause 4.6. So.
No, you are not, you are reading 3, you have to read only what is written.
I'm reading that.
It's not justified, updated stock justified cost, finalized by owner as on the last date of its submission.
Yeah, your lordship's order.
The other one is not.
He's right.
The APS will have to be below, whatever amount is below 15%.
So plot 15
This is right, he's right.
My friend is right. Mr. Rodki is right. Your lordship very clearly said clause 4.6. Clause 4.6 talks of the justified cost. They have quoted it at page 7 of the application. So my friend Mr. Rodki is absolutely right.
No, you correct the tender document accordingly.
It shall be done, my lord.
Because not the last date is tomorrow. That is why we mentioned to Lord.
Today, you issue the corrigendum today.
My suggestion is not, they should extend it by a week so that people know.
That's right.
When they
That's
correct
correct.
over
Very fair.
Can be done.
They can do it.
Can be done, can be.
Name for one of the 9 who is also eligible, my lords, technically qualified. We are all supporting this. Your lordship's order was very clear that the reserve price is as per 4.6. And that is what has to be done. So it can't be 15% on 8,000 crores. It has to be 15% on 10,000 crores. No difficulty. We are only saying that this has gone on for so long to today give an APS of 390 odd crores. You will have to give us some time, my lords, only to say within a week we'll do it. At least 2 weeks to give that.
Is not on record.
No, not party, but I'm one of the 9 bidders. I'm one of the 9 bidders. But we need just 2 weeks.
Only be corrected.
At the most, we agree with Mr. Rodgi and
That's right.
Mehta that 1 week period.
All that we are saying is we were not made parties, but we are.
Out of 9, you are 8.
You are not made party because you are not the petition before the High Court.
But one of the 9 who are eligible as per your
order to bid. You submit the bid and
all that we are humbly requesting is if you could get
for
that.
Not only one request, my lord. There is one inadvertent error which has kept in page 18 of your lordship's judgment. Just have a look. It's apparent on the face of the record, my lord. It's a typo. Para 6, page 18, para 6
of the application.
Of the application, my lords. My lord, 10th line from of the successful tenderer. Your lordship gets, my lord. Of the successful tenderer.
From none.
I'm reading that, but first you have to identify the line there.
None of the parties.
None of the parties.
My lord, your lordships have, my lord.
None of the parties.
Yes.
None of the parties.
None of the parties quoting a price below that already quoted, Mr. Rodgi, by the successful tenderer shall be considered. It should, my lord, either it should be above shall be considered or considered should be should go. Here, my lord,
it should be above, not below.
It should be 2 negatives, my lord. Therefore, it should be above. Below should be above.
None of the participating putting a price
above the already quoted by the successful tenderer shall be considered, and the financial bid shall be taken only from those.
That's why it has to be above.
Above.
Or it can be not a price better.
Yeah.
Then that is good.
Above is better. Above better. Above stock better.
The present I has been filed contending that there has been an obvious error in the amendment to the notice dated 21st of August 2025. First, correct.
Also, not clause 26, it should be 4.6. 23.6, not 26. 23.6.
Where?
Sure.
5 lines below that.
It's the same.
Yeah.
It's 23.6.
23.6.
The same parameter last 4 days.
23.6.
As stipulated in clause 23.
It should be APS.
23.6.
It is submitted that the federal of the order by this court clearly shows that if a bid is submitted, which is below 15%.
Not petitioner, any.
If the bid, that's it.
Bid, yes.
If the bid is submitted below 15% of the upset price or of the base price, there has to be a justification for such a bidding. It is further as per the order passed by this court additional performance security will have to be provided for the difference between the 15% and the bid quoted person. Please, Mehta the Learned, Solicitor General appearing on behalf of the Coal India Limited clearly concedes that the amended notice and error has been kept in the amended notice and the corrected notice in accordance with the order passed by this court would be issued during the course of the day.
Yes.
He further states that 1 week's period would be granted so that the parties get a sufficient opportunity to submit their competitive bids. We find that the proposal made by the Learned OBC is fair. It will enable the parties to offer their comments. Well, but it is fair. The parties will get 1 week's time to offer their comment and
no, not offer, to comply with it.
No, they can also. We are going for reverse bid. So all those 9 should be entitled to submit their bid.
Correct. Offer their bids, my lord.
That's what we said. We said submit their bid. So we say offer their.
No, submit it. No.
Submit their bids. Good so. Right. It's stated that there are certain dates, but typographical errors in the order dated Swan. It's in paragraph 6. So यहाँ पे correction कर लें. None of the participants putting a price below की जगह with read as above. 26 की जगह पे 23.6.
Lord, one more, my lord, thing which we need, my lord, from your lordship's order. Lord, this entire process takes about 6 to 7 months. We are at the fag end now. Lord, since now there is an intervention by your lordships and now there is a change. Lord, suppose L1 who bids with enthusiasm and fails to pay the, my lord, this APS, then we will go to L2. We can't have, my lord, 6 more months because every day the country is losing the court.
And if L1 does not comply, his entire security performance amount is forfeited, and that's not a problem.
Sometimes, my lord, they come and argue that now you restart the bidding.
So if somebody says you are permitted to file an application.
Kindly, my lord, kindly qualify that, or
not we can't.
That if L1 fails, L2 will be granted, no fresh process.
That's a part of the tender process. Why?
That shouldn't be said.
We can't anticipate everything they are saying.
Just one request, my lord, if you also would consider 2 weeks, my lord. 2 weeks. Just consider it, my lord, because everybody will get an opportunity, my lord.
Yes,
yes,
instead of 1 week, it says 2 weeks.
That's all, my lord, because the amount involved is such by the time we organize the bank guarantees.
Well, 1 week is good enough. If you have money,
2 weeks.
Please.
It's the Kerala judges, they have all influence of Justice Krishna Iyer. So
influence of?
Justice Krishna Iyer.
So, yes, even not understanding pronunciation is difficult. Sometimes I am unable to pronounce.
Naidu was sitting with me at Bombay. Yeah. I used to have some difficulty in understanding the judgment of the price.
Not far more comprehensible than the judge who retired from Punjab.
No, that
was incomprehensible.
You can't compare.
No, there is no compare.
I read your lordship's remark. It was quoted. Lordship Chief Justice's remark was quoted in all.
My Lord Justice Anjaria may perhaps not be aware.
In Karnataka, the lawyers speak English like.
Lord, there was one honorable judge, now retired. There are 3 orders by this court by different benches that we are unable to understand what is the impugn order. Therefore, matter is remanded.
Including the council.
Lord, in the famous judgment, Justice Krishna Iyer talks about the effects of liquor.
Effects of?
Liquor on a person. So he uses phrases like, Lord, lachrymose, comatose, and 1 or 2 other phrases. That you start with this and you end with this. That's a passage I will give you the citation.
For whom we are giving that?
not misunderstand, not the nature of phrases.
But he could remember only one paragraph from Justice Krishna here regarding liquor. Obliged.
Very good. Thanks. Very good.
My lord, this person with impeccable integrity, my lord, 30 years of conscientious service to the nation and to the world, my lord. He's a highly respected person. It was a mistake. He apologized.
We withdrew also immediately.
Yes, sir, I deleted. I apologized publicly, my lord. After that, an FIR.
You should notice. Normally, you would not have entertained.
Yes, I do, man, normally.
You should notice. They have the position.
Grateful, sir. No, no, stay here.
By identity, what is they have the position.
So grateful, sir.
Very good.
What is the contempt? Who is appearing for Indian of India?
It's a contempt of undertaking, which has been given in by the ASG, that these vendors who have been given in, who come in the daytime and leaves in the night, they should not be touched,
The notice written about 4 weeks.
They should be allowed to vet
No, that can't be by an interim order. You can't get that released in a contempt order.
They have been removed on day-to-day basis.
Sorry, madam. Sorry.
Please.
Yes, Dr.
In item 12, your lordship's fellows might think reading it, there is never any ban on stone crushers. We do no mining, we have nothing to do with mining. Material mined elsewhere comes and we do crushing. Now this is important, I got the map here, Melissa. There is a stretch of, this stretch which is banned is Raiwala to Har Ki Pauri. I am 9 kilometers ahead. After 9 kilometers, 1 more kilometer, there is a ban on mining. I use the mined material beyond 10 kilometers. I'm only a crusher. I'm only a crusher.
Who is appearing for the...
And I file an impleadment.
I appear for the state. There is some merit in what they say. The lordship comes to page 17 of the paper.
As a policy, the
page
state
17. The last paragraph. The lordship will find the upshot of the discussion, paragraph 27. We are of the opinion the state government committee illegality in withdrawing the ban imposed by the OM dated 24/8/2017. This is at page 191. And after 191, if your lordship will come straight to 231.
Superseded.
231. At 231, that OM of 24/8/17 was withdrawn in October by a speaking order, which is the 231, saying that the High Court recalled its order, which was the base order of 24/8/17, and therefore 24.
They are beyond how much area from the Ganga bank?
Your Honor, I appear for the caveat, Your Honor. I am the original petitioner before the High Court, Your Honor. Your Honor, there are multiple orders of the CPCP, or orders, Your Honor, just brief facts of the case, Your Honor, because it's very important. The High Court never reviewed its order. I'll directly come to the facts on the, which have been noted down on the SLP, Your Honor. Your Honor, there...
Let him respond to it.
Yes, Your Honor.
I'll take less than 3 minutes. The point is point C in the middle of the map. It's not a very good map. Yes. And up above that, Raiwala, point B. Now, this is a ban on mining. I am not a miner, I am a stone crusher. I am located right down at the bottom at D. Jayapata. That is 9 kilometers away. Now, pause.
9 kilometers away from the bank of the Ganga River, or?
No, 9 kilometers downstream. And there's a policy of Mr. Rohtgi under which he specifies at which point how much distance from Ganga. 1 kilometer, half kilometer, 2 kilometers. I admittedly comply. This judgment has been written in a mix-up manner for the reason that they think they are banning sand mining. I'm not a miner. And what happens is, there is no ban ever on me. I file an impleadment. Because I made a foolish thing, the oral observations are made in the court hearing, so I filed an impleadment. On my impleadment, A stone crusher ban is inaugurated in the impugned order. That's the problem. One of the errors the impugned order, Mr. Rodgi has pointed out, that is well as this reliance on 24.8.17, which is a document superseded at page 231 by 16.10.17. Now, 16.10.17 notes the two orders of the High Court. 24 August, just turn to page 17. Page 17.
No, 24th August 2017
is page 191. It's at page 191.
It is superseded by?
Is superseded by page 231, 16.10.17, which the High Court unfortunately omits to note. Now there is something more interesting after that. Just see that. 231 and 231 gives your lordships the orders of the High Court, which are quoted.
Where is that 9517 order?
Yes, 9517 order is also there.
From which 231 error?
Yes, yes. I'll just show that. Which is the page 9517. Just show that. Minute. Also note there is a stone crusher policy. Just see that at 266. It gives your lordship Chief Justice's query about distances. 259 at 266. 259. It's an official policy of the state of UP, Uttarakhand, and well as at 266. This policy is not under challenge.
What are the standards of distance for the application of stone crusher?
Yes.
Begins at?
Begins at 259. Just see relevant one page, 266 and 267.
No, it begins at 260.
Whereas this particular policy is 259.
The governor in the interest of mineral development.
No, yes, that's 260. Sorry.
11 November 2021.
Apologies, 260. 260. Relevant is at
259 appears to be a covering letter.
Forget my mistake was not 259. Not 259. It's 260. At 266 is the question, my lord, the Chief Justice asked. Now, amazingly, this policy is not under challenge. Nobody challenged this policy. Give me that order.
Government for is 100 meters from the banks of the river Ganga, 1 kilometer, 1 kilometer. For other
different points.
Is your contention that this stone crusher is being run in violation of this?
Your Honor, just a couple of minutes, one brief facts and straightforward facts, Your Honor. Page 187, Your Honor. That was the first order of the CPCB under section 5 of the EP Act, Your Honor. The second point of the directions of the CPCB, Your Honor. In view of the required action needed to stop illegal mining communicated by the district magistrate.
187.
Page 187, second point, Your Honor. That's specific directions pertaining to the stone crushers, Your Honor.
Yes.
Yes, Your Honor. Now, this is for the closure of stone crushers based on a recommendation of the DM Haridwar, which was captured by the CPCB, and directions under section 5 were issued, banning stone crushers in the periphery of 5 kilometers from River Ganga. This is the first point, my submission, Your Honor. The second submission, Your Honor, the Uttarakhand High Court gave categorical directions to implement those directions of the CPCB, wide order dated 3rd May 2017, Your Honor.
Of the required action needed to stop illegal mining.
Yes, Your Honor.
By Haridwar in the that issue necessary orders immediately for closure of operation of stone crushers.
Stone crushers, yes, Your Honor. Yes, Your Honor. Now, page 229, Your Honors. Straightforward facts, Your Honor. Yes, Your Honor. Now, on 3rd May 2017, Uttarakhand High Court gave categorical directions to implement the CPCB directions dated 6th December 2016. Post that, these 48 stone crushers who have filed this SLP were closed down pursuant to a contempt petition that was filed after the 3rd May 2017 orders were not complied. Now, after the stone... Yes, Your Honor.
Find out from this.
Yes, Your Honor. Sure.
229.
229 is the review order which they claim, pursuant to which they claim that they were given permission by the Uttarakhand High Court to reoperate those stone crushers, Your Honor. Now, para 43, Your Honor, I'll directly point out to that. Yes, Your Honor. In such circumstances, I'll just read out that important paragraph, Your Honor, because that's the crux of the matter. Based on that, the illegality was committed. In such circumstances, we are of the clear view that in exercise of the power of review available to us, we should interfere and recall the judgment and restore the writ petition back to file. This is what they claim, that the CPCB directions after this particular review order stands revoked and the Uttarakhand High Court recalled its previous judgment. That is 3rd May 2017 judgment. Now, Your Honor, the second paragraph of the same 43, we have only reviewed our judgment by which we have given a positive direction to the state to implement the directions of the CPCB. There were categorical directions that the Uttarakhand High Court never interfered with the directions of the CPCB that were already in place. Now, Your Honor, the 48 stone crushers that have come in the SLP before this honorable court, they were banned pursuant to this filing of this particular review application. The stone crushers were a party in this particular review application. They were heard and their contentions are recorded, Your Honor. Now, pursuant to this,
was filed by whom?
Your Honor, the review petition was filed by the state, but the stone crushers impleaded and they were made party respondents, as well as their contentions are already on record in this particular judgment, Your Honor.
Where is the 49?
The judgment starts at page 188. The 3rd May 2017 judgment starts at page 188, Your Honor, which is the first direction by the Uttarakhand High Court to implement the directions of the CPCB. On page 191 is the order for closure of stone crushers, which the state complied and submitted before the High Court that they have closed all the stone crushers. And Your Honor, a very important submission. The matter is listed for final hearing on 12th September. This is not, yes, Your Honor, this is an interim order. And other part of the main crux of the matter is, Your Honor, an SLP was also filed before this court on one of the interim orders and it was dismissed by the Honorable this court, Your Honor. And the other important part is, Your Honor, the judgment of the Uttarakhand High Court confirming the CPCB has been finalized on 5th September 2018, Your Honor, that the judgment has been crystallized. No appeal pertaining to that has been filed. Pursuant to that, NMCG, which is the...
I just want to take...
Sorry.
This order, this order which my learned friend has shown at page 187 is only saying as applicable, as per the policy. That word applicable...
No, not applicable. The CPCB has directed all the structures between A point to B point to be stopped.
Just see that for a minute. Very well. Just see that for a minute.
Thank you, Doctor.
That order...
Thank you, Dr. Singh.
187.
Thank you.
Well, this is the case of complete systemic failure. SIA is not being allowed to function. Fortunately, now the chairman has come with an affidavit before my lords, and he's given his woes of problems. The senior IS officers, they want to run SIA, my lord. My lord have constituted SIA as a separate body. It's supposed to have a degree of independence.
Yes, who is appointing for state of Madhya Pradesh?
State of Madhya Pradesh.
No, you must have an independent power. The CIA, who is appointing for the Union of India?
So far as
who is appointing for, you are not implemented MOEF.
Yes, we've implemented them, we've written to the...
It's the responsibility of the MOEF to appoint a CIA.
CIA has been appointed but made ineffective by the ego problems of the IS officer. He is a promoted IS officer coming from Deputy Collector's cadre. The other IS officers, they granted 237 clearances without CIA meeting. 205 days, no meeting. Means nothing doing, my lord.
You are appealing for whom, Mr.
Respond number 3, my lord. I have been writing letters to them. 50 letters I have written.
You are the chairman of the CIA.
Chairman of the CIA appointed by the government.
You are not functioning.
Huh?
They don't permit you to function.
Yes. Even I was not provided a car. My office was locked.
No, but whether the Other members of the CI have been constituted.
No.
Yes, there's a member.
Raghuvanshi, they have
The lady member, she is also facing.
All the CI has to be appointed
Yes.
by the MOF.
Yes.
MOF.
Where is Miss Bhatti? Just get her. Have it after 5 minutes.
Yes.
You can get Miss Bhatti immediately.
I'll tell her.
This is something serious.
Yes.
Your IS officers are granting permissions, but taking the law, entire law in your hand. The state is that was the grievance that the state is granting mining permissions even without there being an approval of the CR.
No, don't tell all those things. You are the chairman, be responsible. Don't tell all this against the state. Mainly a statement or oath.
He is your officer.
Yes, that's what.
We should, appreciate his independence. He is not succumbing to the pressure of.
He should not. He should work independently with regard to the entire functioning of the system.
Not at the dictates of senior officers. Otherwise, the very purpose of appointing CR to be an independent body itself is frustrated. Anyway, you get Ms. Bhatti.
From the state is concerned on facts, you have to file the counter or this one.
We get Ms. Bhatti first.
Yes, first we'll get her.
Of an arbitrator, my lords had issued notice on the last date. The arbitration clause is at page 22.
Yes.
Because this is an international commercial arbitration seated in Mumbai.
Mumbai, yes.
Because if we are not objecting, there are only two things, my lords. They can suggest a name, we can suggest.
They have suggested, I think this is.
Yes, they have suggested Justice.
This is Majidar and this is Anil Menon.
We can suggest one name, my lords may appoint a presiding arbitrator. Because the arbitration clause doesn't say whether it should be sole or three members.
Yes, sole arbitrator, my lords may appoint any arbitrator or my lords, whatever my learned friend wants, or my lords can appoint a sole arbitrator.
Sole arbitrator, my lords,
retired judge.
international arbitration, or let it be three.
Leave it up to my
lords.
Lords, it is about $3.6 million US.
25 odd crores, my lords, include my principal of 50.
Let it be 3 members because
we can suggest a name each, my lords. May
suggest one name.
Please, my lords.
From Bombay.
Please, my lords.
You suggest one name.
From Bombay.
And we will appoint a presiding officer.
That's what only thing, my lords, I wanted to point out. My lords may leave all contentions of jurisdiction and merits.
Yes, jurisdiction, limitation, everything, yes.
The limitation and stamping issue amongst other issues.
Stamping we have already held.
That's why I don't want to raise it here. Also leave all of that open. We'll suggest a name. Also,
ARM Global 3 or 4. What is?
Yes. In the review, they can forward a name. We can.
Are you ready with the name?
Either of Justice Menon or Justice Wazifdar, my lords. Have
you spoken to them?
I haven't, my lords. So can my lords have it then?
We'll have it on Monday. Then what are the names suggested by you?
It was Justice Ravi Deshpande.
He is from Nagpur, so whether you ask whether he will be willing to come to.
May keep it on Monday. I'll take instructions for client. Let them come with a name. We'll come with a name.
And then you are proposing either Justice Wajidar or Justice Menon.
Please, my lords. I'll ask.
Ask their willingness.
Please, my lords, I'll ask.
Monday.
And then you ask Mr. Deshpande. I don't mind if he is willing to come from Nagpur to Mumbai.
I'll come back on. I'll get back on Monday.
And then presiding officer will appoint.
Yes.
To Justice Bhosle. He can be considered if the retired chief justice, because if there are one of them is a retired chief justice, it is better than the presiding arbitrator also.
Yes.
Retired chief justice.
As your lordship pleases. We'll come back on.
We'll come back on
Monday.
Great for months.
Your Lordship, I am against an judgment of the Honorable High Court of Delhi, my lords, where my lords
service is not complete, my
lords, they've appeared.
Let the service be complete.
You are the complainant. Lords, I am the complainant. I am the respondent in this matter. Please sign wakalat. We have filed the wakalatnama. We are ready to argue.
Yes, he is ready. Then proceed. What is the matter?
But in this, my lords, our complaint under section 138 of the Negotiable Instrument Act was caused on the basis of a typographical error, my lords, in one paragraph of the notice, my lords, of the demand notice. My lords, may please have my demand notice, which is at page number 28 of this petition, my lords. My lords, the issue that arises over here is, in one paragraph of my demand notice, I have clearly mentioned the check number, the bank from where it was drawn, and also the amount. Now, my lords, in the last paragraph, inadvertently, my lords, as part of a typographical error, I by mistake, the council, my lords, by mistake, noted down mentioned the check amount as rupees 2 crores instead of rupees 1 crore. But apart from that, my lords, nowhere is this is there a demand of rupees 2 crores, my lords. Only on the basis of this typographical error, my lords, my complaint was dismissed. My complaint was quashed, my lords. And also, my lords, this being a penal.
Lords, I am supported by 3 judgments of this honorable court, my lords. One, section 138B, my lords, is clear that what you have to ask is the check amount and nothing more or nothing less than that, my lords. Suman Sethi is the first judgment. Rahul Builders is the second judgment. Delhi High Court has quoted about 15 judgments in its order, my lords. And then this was passed, my lords. In reply to my discharge application, my lords, I filed a discharge application before the learned magistrate, my lords. And there they say that since simultaneous notices were issued, therefore it was copied from the other notice, my lords. Lords, that other notice was subsequent to this notice.
You can file a fresh.
Sorry, my lords.
You are not barred from filing a fresh complaint by after.
My lords, it was back in 2012, my lords, this complaint was filed. I do not now have the option for filing a recovery suit also. My lords, I'm time barred, my lords.
Well, what can be done? The courts are, the judgments of the courts are against you.
But my lords, as regards Suman Sethi, my lords, Suman Sethi in itself says that the notice has to be read as whole. Now, my lords, when one reads my notice as whole, my lords, it is absolutely clear that on one part, it is clearly stating that the amount is this. And on the next part,
the check number. Please, my lords.
He has mentioned
my lords, the point is not check number, my lords. The point is what is the demand that you have made.
Also,
all those judgments, 15 judgments are quoted by all over India, my lords. And all of them say what is important is the check amount. What is the demand? If it's an omnibus demand, you are gone. If it has separate portion of interest, separate damages, separate things, and it can be read into different parts, then yes. Here it's an omnibus demand of 2 crores, which is, I would say, my lord, they asked for double the amount of the check.
My lords, had this been the situation that the double of amount would have been asked, my lords, I would not have mentioned the check amount, the check details of the check in the first paragraph. In the paragraph wherein I'm giving the entire details. Apart from that, my lords, in the last paragraph also, I've clearly mentioned that this is the check. I hereby call upon you to make payments of the aforesaid checks of rupees 2 crores, which, my lords, is undoubtedly a typographical error on my part.
These are technical to suffer for your mistake.
But my lords, this is a quasi-criminal proceeding, my lords.
There is a FIR against this person in these proceedings.
My lords, this is...
Entity is there.
My lords, may just give me 2 minutes and I'll clarify that.
Yes.
Just 2 minutes. My lords, may kindly have page 44, my lords, of the paper book, my lords. What do they say, my lords? Why is there a typographical error? They say that I issued 2 notices on the same day and one of them had a figure of 2 crores and it was a copy paste and therefore it happened. My lords, may kindly have page 44. Para 2, page 43, it starts with para 2, my lords. That the notice dated this is perfect and if the contents of the entire notice be read as whole, the said demand, the aforesaid check and the aforesaid check has been clearly described in para 4. However, due to typographical inadvertent mistake, 2 crore has been mentioned after the word aforesaid check. It is very relevant to mention herein that
You are written notes.
Order.
Written submission plus orders. We'll examine it.
My lord, just one thing, my lord. If my lord will just permit me to show the notice, my lords, that
say whatever you want to say in your written notes, we'll consider that. Written notes will be submitted within a period of 1 week from today.
Please do.
Grateful, my lord.
Your Lordship, I'm seeking further time to
Later.
rejoin.
Later.
This comes after notice, lordships. Very interesting case where the conviction is solely on a basis of a green shirt. Now, PW1, who happens to be an injured eyewitness, he says the green shirt is worn by a person who has been acquitted by the High Court, A1. And the conviction of PW8, one of the others have turned hostile. Even the injured witness has turned hostile. All declared hostile, my lords. In fact, one happens to be an injured eyewitness. He says accused Ravinder was wearing a green shirt. Lordship, 7 years, 4 months actual. Page 100 is my custody certificate. Lordship issued notice on bail also last time.
Yes, so it was
Kindly we pass it over. Honorable Counsel is on court number 2.
Who?
Court, Mr. Jevesh Prasad.
But it should come within 5-10 minutes. Otherwise, we'll...
Yeah, we. 25 minutes coming after notice. I need time to file my wakalatnama and reply, my lords.
You have only issued notice whether it can be converted to 304 part 1 or 2. It's a question of single.
Yesterday I was told to appear in this matter. I don't have a paper book, my lord.
Next Monday.
Pleasure.
Wait, please, the court. Well, look, now it's fairly well settled by a number of decisions that limitation also is decided only by the arbitrator.
Yes.
So that's the only ground on which I've been thrown out. So, well, it's like, we'll leave it to your lordships to appoint anyone. This will get over in no time. This will not be a complicated arbitration at all. There are notes on their file accepting my claim. These notes were as late as 2016. They had processed the whole claim, alerts. In the file, the amount is also quantified.
Yes, Mr.
Look, kindly have a look, my lord. What is
opposing?
Pardon?
So opposing the bill.
I am opposing.
You have to go on some NMD because you have to rise.
Well, it's an 86 claim.
No, my lords, that's not correct. I'll just point out.
NMD correct.
I am obliged.
Work completed in 1987 and the claim raised in 17.
It's
obliged.
And his father, even after his father passed away, he waited for a considerable.
Yes, madam.
Anyways, we'll have it on something.
Great.
So item 27, we've not been able to.
Yes, please, I think where is Mr. Nataraj?
So item 40 also, I will take instructions, your lordships.
You have to appoint a CI
My lord.
and also ensure that the CI is allowed to function. Mr. Nataraj's officers cannot serve the jurisdiction of CI and start granting permissions.
My lords, may I have it next week? Permit me to get instructions.
Next Monday.
Yes, my lords. My lords, item 27, I'm requesting for time. We've not been able to file our reply, my lords. Though we have complied with it, it's arising out of impugned order from in contempt proceedings. I'm carrying a charge, but permit us to place it on record, my lords.
2 weeks. 2 weeks or 3 weeks?
My lords, 2 weeks, my lords.
Could we come, my lord, some fixed date, but matter is pending for 1.5 years only.
So he's saying that.
I'm carrying a chart, but my lords, 28 can be allowed in terms of your lordship's judgment.
Yes. Let me the petitioner here.
Your
Actually,
lordship's
there are
judgment.
what sorts of 2 days for my pension as a registered High Court judge.
Involved in the present case has already been covered by the judgment of this court. Which one of us provision of the party in the case of Swan. The respondents are therefore directed to pay full pension. The petitioner who has retired as a High Court judge in accordance with the said judgment. The pension in accordance with the aforesaid judgment shall be paid regularly from the month of September 2025, all areas from the date of retirement to the date of superannuation till 31st of August 2025 shall be cleared with interest at the rate of 6% per annum within a period of 3 months from
Great.
For the respondent minutes. Issues regarding. Yes. The student is
my lord.
Yes, Mr. We had issued notice because it was your first matter.
My lord,
may kindly excuse me. I will not take more than 3 or 3.5 minutes. I have given a chart. If I can make the point within that time, I will not stretch it further. I am complaining that the action is arbitrary. I am not on the point of challenge to the regulations. They have granted additional attempt to earlier 2 batches on the ground that they were affected by pandemic.
By COVID, yes.
Yes, Lordship. And we stand on par with those 2 batches. That is the submission. I can point out from facts.
Where is the chart? Yes, Mr. Counsel.
My lord.
Who is assisting you?
The brief is yet to come.
Huh?
I'm not aware of the chart, my lords.
No, but Mr. Haq is saying that he has passed on the chart.
No, I have talked to Mr. Desai, Mr. Satyajit Desai. He said it is on record. My lord.
Pass over the matter, my lords.
It is have you annexed it to the petition?
My lord, I can directly go to the 2 or 3 pages, my lord. Page 89.
Okay, yes.
My lords, may I read?
Yes, please proceed, yes.
Page 89, first para 2, my lord. The curriculum of UG 2021 will begin from 14 February. What happened, my lord? As per the regulations, we are
You are admitted in which year?
21-22.
21-22.
So, as per the regulations, the admission should have been finalized till 1st of August 2021. Now, these admissions were given in February, March 2022, after 6-7 months. And it is because of COVID, that is their own document says that at page 89. And my lord, we were felicitated as Corona warriors. We have worked there. Now, my lord, it is not a question that what is the position at the time of exams. We have suffered during the process, my lord.
When did you appear for the examination?
Yes. My lord, the first was in, my lord, before that, can I point out one relevant fact on page 6, my lord?
Page?
Page 6.
Yes.
Small Roman 2. Pandemic was running since January 2020 to May 2023. It is pertinent to mention here that the WHO ended the public health emergency of international concern for COVID on 5th May 2023. And immediately we appeared for the exam, my lord. And because of the delay which occurred in the earlier batches and our batch also, the period of second attempt was reduced from 90 days to 30 days. Same thing happened for third and fourth attempt, my lord.
Yes, Mr.
And just one second, my lord. This is the point. And nowhere they have answered that. They have not put up the document to show what is the basis for coming to this decision that we are not affected by COVID and therefore we are not entitled. Just our representation is rejected on the ground that there is fifth attempt is not available.
Yes. Lord, this is the batch of the academic year 2021-22, my lord. The COVID, the lockdown happened in 2020 and in the beginning of 2021. These admissions were made later on, my lords. They completed 1 year, my lord. They appear for the examination on 9/2/2023. After that, my lord, the rule says that within 90 days we have to conduct supplementary. It is not done by NMC. The regulation is there. It is done by the concerned university, affiliating university. They conducted examination. She took 4 chances, my lord. In all 4 chances, she failed, my lord. The regulation is there. There is no such similar case. And the batch of the entire batch has passed, only one student has failed, he can't claim parity.
There are lots, my lord.
The similar issue came before
intervention.
this honorable court regarding IAS examination, also UPSC, my lord. That time also 1 year relaxation was given, my lord. We have reproduced the relevant para, my lord. The relaxation can't be continued for year after year, my lord. Indefinitely. We have already given them 4 chances, my lord. Kindly consider, we have...
How much are the regular chances, routine chances?
I beg your pardon?
How much chances you normally do as per the...
4 chances, my lord. The regulation provides 4 chances, my lord. And the petitioner has availed all 4 chances. Kindly see, from last 4 years, she is in the first year MBBS.
Not only one, there are 4 petitions.
No, apart from this, my lord, there are many, they have moved high courts. Their matters are pending before honorable high courts. Therefore, to curtail these various litigations, I have advised that one SLP is filed and one petition under Article 32 is filed so that this issue can be settled. There are more than 50 students and, my lord, they have given additional 5th attempt to 2 earlier batches.
Page 106 and 134, my lord.
Students admitted in which batch?
1920 and 2021.
The similar issue came before this honorable court, my
now
lord. At page 134, my lord. Kindly see page 134.
My lord.
Kindly see page 134, my lord. Of the SLP paper book, my lord, annexure 8.
SLP paper book?
Yes, my lord.
Yes.
I'm sorry, read paper book, my lord. 106 is the Delhi High Court order. Against that, my lord, the SLP as well as the writ petition came before this honorable court, my lord. The similar petition, my lord, where the regulation was also challenged and this court has dismissed it, my lord. Because, my lord, in case anything be given for these students, my lord.
Dismiss.
Right, man.
Respondent has not filed counter in this matter yet.
Yes, madam, you have not filed counter.
Sir, I am the respondent.
You have to file counter.
Sir, I have moved an application under section 142. This, your lordship has dealt with the matter.
Consider this out. Some other day. Yes.
Please. Lord, this may take some time. I would request my lords to place it on any NMD, my lord. Pleadings are over.
NMD,
right.
After the CV.
Some date be fixed.
They'll give after the CV.
Vote for state. अरे dismissal का matter.
Yes.
Item 32.
I'm seeking a pass over.
In this matter, your lordships have already dismissed one of the SLPs arising out of the order, my lords.
Yes.
Wherein your lordships had directed the selection committee, my lord, that order.
He is seeking a pass over. Some other day. Letter.
33 minutes, I will request to have next fighting.
Yeah, there is a letter, so as per the letter.
Because only reason is counseling is ongoing, lords.
Okay, next.
Lordships, I appear.
May I please your lordships? Lord, these matters have to be heard. Classic case of NGT at outsourcing its adjudicatory functions, giving everything to a committee and accepting the committee's report, which gives no notice, no hearing.
But that's nothing new.
Yeah, I know. I'm just saying. One more, repeat.
Nothing new for the NGT.
Yes, yes.
Anyway, but today it can't be heard.
May I just...
Your lordship may hear it on any convenient day.
The interregnum 2 directions can be passed, your lordships. Can I just pray for that? I don't think anybody will have an objection. This is a matter, your lordships, pertaining to, I'll just take 2 minutes, your lordship. This is coal affected areas. Now, the demand has been stayed by this court. It was done in 2020, but there were certain directions passed by the NGT which were not stayed, which are very urgent in nature. One is to provide medical assistance to all the victims who live around that coal mined area. And there was supposed to be a committee set up for remediation of the area and the money to be taken from the district
Mineral Fund. All I'm stating today is, your lordships, let the chief secretary, because he's been appointed as the nodal officer, at least file a compliance before this to this.
Which order?
Yes, this is the order dated, your lordships, the second order, the final order. Give me the date of the order.
Final order of the NGT.
No, not final order. The order impugned before this court, your lordships, in 2825. It's order dated 23/3/2020, your lordships.
23/3.
By the NGT.
No, by the NGT, impugned before this court. There's been a stay of demand. The other directions haven't been stayed, where certain compliances were required.
Is the Chief Secretary party here?
No, Chief Secretary is not a party, but he's been filing compliances before the NGT, your lordships.
Sorry, the Chief Secretary of. Is in which state?
Chhattisgarh, your lordships.
Of state of Chhattisgarh. Would file an affidavit before this court, pointing out therein as to what steps are taken for providing medical aid to citizens residing in the vicinity and
Remediation steps.
and remediation measures for such citizens. That affidavit will be filed within a period of 4 weeks from today.
Yes.
The registry to
Yes.
forward a copy of the order to the Chief Secretary of.
Your lordships may also just suggest that since this matter, this is a civil appeal, if the leave, let it be admitted and it will come at least in the hearing list, your lordships. They also, we can't have a problem with that.
Leave granted. I admit.
Your lordships I can request for it.
We don't know because after the.
Lordships, because we've been suffering a stay from 2020.
Only after CB can take it.
Date for me.
Your lordships can give any date, even September, just any date.
October.
October, I'm obliged.
Deeply grateful.
I'm obliged.
Now, Manas, your lordships have stayed, Manas, the order the other day. Now they say that you implement the original order, which means you supersede, Manas, what is happening thereafter. So we want a stay of the original order, because in the original order at page 208, Manas, he said that the government of West Bengal is the state legislature. Kindly see page 208, Manas, of the origin of the petition, Manas. And so, Manas, we can't implement anything. We can't hold
there's some letter, I think.
That's right, Manoj, because this application was served on Saturday on us. We want time to respond to it.
No, forget the application.
We
don't want to argue the application.
We need to, Manoj, respond to this item.
Just allow me, sir. Allow me, sir.
Let it be on Friday.
I'm sorry?
Let it be on Friday.
Friday.
Yeah, it must be, because, Manas, we can't.
Can it be Monday?
We can't carry out admissions.
Okay,
Monday. We'll file a response.
Coming Monday.
Yes. Right. Very well.
May please lodge. This is the IF for direction, directing state of Maharashtra to give appointment to the candidates who are already selected and schools were allotted. Lodge, may I just give a facts of this case? In 2019, Governor of Maharashtra had issued notification notifying the area being a PESA area, that is scheduled area under 5th schedule. Subparagraph 1, paragraph 1.
May I submit, Lord, this matter will need to be heard. This is 100% reservation in tribal areas under paragraph 5 of the 5th schedule. In 2 cases, in Chebrulu in Andhra Pradesh and Satyajit in Jharkhand, your lordship have already struck it down. It's a constitution bench Chebrulu. Now in para 16 of the application, he says the law is wrongly decided there. It needs to be reconsidered.
Irrespective of that, we are 835 candidates who are already selected. Even if we appointed.
How many posts are there?
Total, just 6,900 is the sanctioned strength in the Palghar district. We are 835 now appointed. Total 1,524 candidates are 1,570 candidates from ST category are serving. Even if we appointed, total appointments won't go beyond 34%.
100% of the advertised posts he wants, not for reserve category.
Monday, have you filed your reply?
We have not filed a reply.
You file your IA.
All right, I will also file. I am the petitioner. I am opposing it.
But what my reference says seems to be correct. And even if all these 835 candidates are appointed, the figure won't cross more than 35.
No, but
No, but according to him, the reservation itself can't provide for 100% reservation.
Correct. In this process, all posts.
One minute, we are saying something in your favor, sir.
Sorry.
Let him respond.
Sorry.
Ultimately, what will happen, even if this petitioner succeeds, the reservation will be restricted to 50%. And
Therefore, you get a factual data on the basis of this affidavit as to how many are the total posts, how many are the total vacancies.
Lordship turn to page 9 of his IA. The data that he has submitted seems to be correct.
But then the state will have to verify it, the Jilla Parishad will have to verify it. Do it within 2 weeks.
So the point is this, that these, even if the petitioner succeeds, it
Yes, we quite appreciate your point. We will permit you, provided the information given by you.
But kindly see, we're not, this is a tribal area.
Yes, therefore we are
Teachers, 835 posts are vacant in tribal areas.
Therefore, Mr. Napade, we said that you verify the data. If the position appears to be correct, we will permit you with a rider that you will not at any point exceed 50% of the reservation.
If I can add, I'll file my reply. I'm grateful. In 2 weeks, I'll file my reply. But the point is, the whole selection process.
The state is willing to argue with whatever date that you
You'll consider first let us at least have the teachers in your schools.
Yes, Lord.
But in fact, this whole selection process proceeds on 100% posts being reserved. I am a person who I am a association registered association who belongs to the general category. The notification is on the face of it bad, my lord. That judgment in Chebrulu is on the record. Kindly see this notification
any category.
and that notification.
Appointments are
2 weeks.
And review. Correct. Your lordship said after
2 weeks.
All right. In the meantime, we'll file the reply.
Lordship, fixed date may be given. Any Monday.
Monday after 2 weeks.
Great.
Kindly see the police report submitted to the Honorable High Court, which I filed as exhibit R1 along the counter. Which says that the fraud was committed by someone else. I am only a victim.
Beg your pardon?
I am only a victim. Your Honor, kindly come to R1.
You are already protected, sir.
That's
You are already protected.
No, this is our petition.
no, I got to attend it.
Petition was by the state of Tamil Nadu.
Yes.
But what happened here is that this cat.
Counseling.
So have it on some other day.
Counseling.
We'll have it on some other day. Today, no.
Monday, Friday, subject to
Okay, Monday.
second counseling, yes. MBBS.
But Monday we'll have it on Monday.
Student, 2 courts were given. The judge as well as division bench passed order in my favor, allowing me to participate in the counseling. So therefore, but the only issue is that I am getting seat under the NRI quota. My uncle is in US, there is no dispute over that.
How can this is a fraud has been alleged against you?
Allegation is that
Anyway, Monday.
My friend is renovated.
Yes. How many years you have undergone?
7 years, 4 months.
Who is for the state? How many years you have undergone? It's case of no evidence.
Because there is evidence of PW8.
Leave granted. Take into consideration that petitioner has undergone half of the more than half of the sentence. We are inclined to allow the petition. The sentence is suspended during the pendency of the appeal. Directed to be released on bail.
Yes, of course.